It's another wonderful edition of the program, My Government and I, on Base 101.1 FM. And indeed, my name is Victor Ita. This is the time where we take our time to look at all the newspaper headlines that made it to the newsroom across the country and, of course, across the globe. We bring you the remix of the issues that made it to the news. This is where we do that. I do this every Sunday, and I tell you, this is where you should stop and be part of. You want to get to know what's going on in Nigeria and what's going on around the world. This should be your birth stop. Again, I'm Victor Ita. Joining me today to discuss issues and discuss news headlines. It's a fine gentleman, a senior advocate of Nigeria in the making. You can say I'm the one that says it tomorrow. It's okay, it's fine. Oluwatodimu Ige is a legal practitioner, a public affairs analyst, and a fine gentleman. Thank you for joining us.
Thank you so much for having me.
Yeah, I wanted to check it. There's a checker I could check it for you.
Thank you so much.
Yeah, one of those lawyers. If I was to be a legal practitioner, I would have said that I want to be like you when I grow up.
I bet you're older than me.
Of course, our looks will tell you who is older. Okay, so let's look at this week. We had very interesting topics and issues. Newsroom were very busy. In fact, I think that this week was one of the busiest weeks in the year 2025. The sentencing of Nnamdi Kanu that got everyone talking, not just in Nigeria, around Africa, and of course around the world. In fact, it's one of those cases that a United States Congress talked about it because a congressman stood up during the interface between Nigeria and the United States. Somebody mentioned that, one of them mentioned that Nnamdi Kanu was sentenced to life imprisonment for, pressing for the rights of the Biafra people. So, get us into the midst of the case, what we should know. And there are cases that, opinions scattered across board that it was just too heavy for someone who was agitating for freedom of his people, or from oppression, freedom of his people, political oppression, political starvation, and, economic sidelining by the federal government. So what is your take? Let's look at the legal perspective of the issue.
Well, like we said, it's been a very busy week, and looking at Nnamdi Kanu's case, it's been long coming. The matter took about 10 years in and out of various courts, and finally the result that we had. He was charged under the Terrorism Prevention Act as amended of 2013. And, there are diverse school of thoughts, but, we are talking about the law here. He was charged, and the maximum sentence, the maximum sentence for that is death by hanging, but, he was brought down to life imprisonment. So that means that...
the trial judge quoted the Bible, I think the book of Matthew. What was the semantics around quoting the Bible?
Well, the learned judge was trying to say that he was going to apply, there's what we call, the maximum sentence ordinarily should be death, but the courts, out of its, in quotes, magnanimity, out of mercy, because there was an allocutus. Allocutus means that a plea for mercy. And he was brought down. As a matter of fact, you see that the prosecutor was gunning for the maximum sentence. After he was found guilty and before sentencing, the prosecution, that's the state government, the federal government was asking for the maximum sentence, and that's why the judge quoted the scriptures.
As well, scriptures, and ended up with life sentence for him, for a man who couldn't defend himself. A man who was, bundled out of courts. He couldn't defend himself. One way or the other, there was no closing statement from him. And yes, you might say that he took out his legal counsels and all of that, but you can't barb a man's hair in his absence.
When it comes to appearances in courts, every defendant, as enshrined in the Constitution of the Federal Republic of Nigeria, says particularly Section 36,
Yes.
says that every defendant, every Nigerian, whether you're in court or police station or anywhere, you have a right of fair hearing. That means that you don't listen to one side of the story and make your decision.
Yes.
Now, having said that, Nnamdi Kanu was afforded that opportunity quite a number of times to open his defense, state his own side of the story, or, whatever he has to do to defend his suit. After some time, if you don't do that, that right doesn't exist in perpetuity. It cannot go on forever. The prosecution can apply to foreclose your right to defend the suit, which was what happened in Nnamdi Kanu's case. Now, aside from that, on the day of the sentencing, like you said, the prosecution gave their own closing remarks. He was supposed to do that, but he was unruly. And the truth of it is that if you look at the video of what transpired, the way he was agitated in court, and as a matter of fact, the court was even very civil with him. As a lawyer, I wouldn't dare do that. The court, it's contempt. There's what we call fascia in Korea. That's contempt in the face of the court. And there was a lawyer years back, I think, Ep1, something like that happened. Yes. And something like that happened, and he was remanded in prison custody, which was a reason for outcry. And he didn't do worse than that, than what Nnamdi Kanu did. So as a matter of fact, the legal profession is conservative to a large extent. We pride ourselves on that and our decorum and mannerism in the court.
But do you expect decorum? Do you expect mannerism from a man who has been under trial for 10 years? For a man who said to have been sick, allegedly so, but doctors were asked to come examine him and then brief the court, and the doctors didn't do anything. He wasn't examined according to him. He even filed a suit against the Nigerian Medical Association for coming up with a fabricated examination for him when they didn't even spend time with him. Why would you expect? He wasn't supposed to come to court smiling and dancing. 10 years it's been, and he even said that it's a mistrial. We'll talk about that mistrial, but reacts to the fact that, I don't know, Nnamdi Kanu wasn't supposed to come to that court looking like me, smiling all over. He's supposed to come there. He even tried to be very sincere. That's what the reality of Nigerians are saying.
Well, in circumstances like that, we say that, yes, he's agitated. At the point the court was telling him, please calm down, sit down. I'll listen to you. That, he went into expletives and all that. We have to look at it. Two wrongs don't make a right. There are other angles available to him that he can explore under the law. If you feel that, as a matter of fact, he exercised one of the rights to recuse one of the judges because he felt that the judge was biased. Now, in this circumstance, if he felt that the judgment was not going to go in his way, or he felt that the court was biased, or there was no competent law to have tried him, he has a right. As a matter of fact, in law, as of today in Nigeria, the issues of preliminary objection can be raised at any time. And if you raise them, the court is duty bound to listen, explore. And if the court refuses to do justice in your view, you can approach an appellate court. The matter is a trial. The trial court was the Federal High Court.
So they still appeal.
Oh yeah, he can appeal to the Court of Appeal, and of course, if he's still not
the Supreme Court,
so he still has those options available anyway.
So let's look at he came and said to the court that, listen, I'm getting off my legal counsels because these guys are not ready to talk. They're not ready to say things the way they are. They're not ready to paint the true picture. So if you were to be one of his counsels, what would you advise him at that point in time? And would you say that was a misfire?
Well, in my view, as a lawyer, and I say this because we are masters of the law. And the responsibility and the obligation placed on the lawyer is to ensure that the best interest of the client is protected.
Are you guys masters of the law or servants of the law? You serve at the law's temple of justice. Are you masters or you are servants of officers of the law?
We're officers. We are ministers in the temple of justice. And, the onus is on us to do justice, respect the courts.
Be seen to do justice.
Yes,
in most cases in Nigeria, be seen to do justice.
We also say that justice must not just be done; it must be seen
to have been done.
Yeah.
Yes.
So that onus is on us. Now, I haven't said that. Yeah. If I were the counsels to Nnamdi Kanu, like I said, these are lawyers who have gone to school to study the law, who ply their trade as lawyers. So it means technically that they know what they are doing. So they would have given a reason in line with the law. And like you said, Nnamdi Kanu would not look at it from that perspective because he's the one that is wearing the shoes and he's feeling the pinch more.
Yes.
The lawyer is coming from the comfort of his home and
he's also going to go home with money, however.
Exactly. So, he would not look at it from that perspective. But there are times that you need to divorce emotions from the law. If you had allowed them to raise his defense, even at the point that he was saying that there was no law and all that, the lawyer knows what to do. If they feel that the court did not rule or do justice by them, they can always go to the appellate court. And they can always exercise so many options.
So would you blame him? Was that a misfire? Would you blame him?
I would say that it's a tactical error not to have allowed his lawyers represent him. And on the other hand also, a tactical error for him to have said that he had no defense. Because what happened in effect was that he rested his case on the submissions of the prosecution. And what was the submission of the prosecution? They had 7 counts out against him. So it means that you are saying that, I accept. And law, uncontroverted evidence, they are deemed admissible.
Okay, so let's take this out of the courts. We'll go back to the courts. Let's take it to the court of public opinion. A certain gentleman who, by you guys, the police, the authorities investigated this gentleman, arrested him, and he confessed to the fact that he led a certain group and that they killed people. People died. A terrorist, a known one. And he went away with 20 years sentence that might even capture his time that he spent in the custody of the state already. But Nnamdi Kanu, yes, you might say that his actions and inactions resulted to the killing or the death of some Nigerians from the southeastern extraction. And the other guy was defended, but Nnamdi Kanu wasn't defended because on its grounds is that there's no law in Nigeria. After all, he won at appeal. Appeal court said his extraordinary rendition from Kenya to Nigeria was questionable. We'll talk about that rendition, but let's stay on compare the two pictures I've painted. The guy who got 20 and the man who is going to go for life. All his life is going to be in the custody of the state. And then he was already posted to Sokoto. There is Africa in Calabar. There are prisons scattered across the length and breadth of this federation. Why send him to an hostile community or area like Sokoto?
Yes, in respect of the other terrorists that was tried, Nnamdi Kanu, you will see that in law, we would usually say that no 2 cases are the same.
But they are both terrorists, aren't they?
Now, yes.
But are they? Let's establish that they are.
Of course, terrorism. Now, that's why I'm saying that.
Yes.
It's quite unfortunate. At times, it could be unfortunate.
Yes.
That the charge that the court is bound to only look at the charge that is before it, not extraneous factors. So there are times that because of the way our system is rigged, whoever is bringing the application to court might not have filed a terrorism charge. They could have filed a manslaughter charge. So at that point, the court cannot give a decision on a fact that is not before it. It's extraneous. So the court has to look at what is the charge. So I don't know the instance that you have mentioned.
Yes.
We don't know what charge was before the court. Because anything that has to do with manslaughter, murder, is, the minimum sentence should be life imprisonment or it should be death. So, when it's not I don't know what must have transpired in that matter, like I said. If that means that the charge could not, maybe the maximum sentence was 20 years. And for Nnamdi Kanu, there was no defense. So he submitted to what the prosecution brought before the court.
Okay, so let's look at. I've taken you somewhere and you refuse to follow me. There, you have recused yourself from following me to where I'm taking you to. I carry you go where you know, but you didn't want to go there. But it's okay. Let's come back and look at the case against Nnamdi Kanu.
Yes.
He spoke radio. He was on radio. He was online talking to his people who have been marginalized by the state. Is it not within? What does the law say about succession? If you want to say, okay, listen, I don't want to be part of a certain entity anymore because I feel that my right is not being protected by the antlers of the entity.
Well, now, for Nnamdi Kanu's case,
Yes.
I studied the judgment. It was about 144 pages.
Yes.
And
I tried, but man, I had migraines. I had to leave.
So,
yes.
The court looked at, the prosecution's arguments and the witnesses that they brought to court stated that his actions, though he was out of Nigeria and he was given a broadcast, and they stated certain examples that he stated that he needed 110 heads, but they were able that day and they brought 10 heads. His actions, his talks, resulted in the loss of lives, and some people who were directly affected by his speech and statements were in court to give evidence. There was an instance that he gave an order on the radio to people to kill police officers and personnel,
bring down police stations and all of that,
which they did. And that's
which they did. Was the court able to prove that they
yes,
did
they
that?
did. There were witnesses that came to court. That's why I said the court.
Yes.
These people were presented to give evidence in the dock. Ordinarily, by the time he was opening his defense, he should have stated that these people on their own volition, probably they could have. I said this statement, it was just one state that was affected. It could not be have been a direct action, my own direct action. That's why if somebody says his own side of the story, the onus and burden on you is to say your own side of the story. You understand? So because it doesn't pay to keep quiet when somebody is alleging that.
Whilst we talk about this, let's not also forget the likes of Simon Ekpa, who in Finland was sentenced to how many years? Over almost the same case and all of that. Do you think if Simon Ekpa was tried in Nigeria that he would have gotten the same fate as Nnamdi Kanu?
Well, yes, most likely. He would have also gotten the same sentence because if he's still going to be under the same Terrorism Prevention Act of 2013, then, if the prosecution was able to establish that his speeches and his actions resulted in the loss of life and hindering the action of the government in power.
So I need you to speak to, we're not focusing on Simon Ekpa, which is in Nigeria, but it's okay. If not in Nigeria, one day he will touch the soils of Nigeria and we'll see the long hands of the law might stretch and get to him. His rendition, let's look at Nnamdi Kanu's rendition from Kenya to Nigeria. And I saw a video, there was a video of late President Muhammadu Buhari talking about he was having a media chat with some journalists and somebody put up a question about Nnamdi Kanu. And then he said, late President Buhari said that Kanu came into Nigeria with he has a United Kingdom passport, has a Nigerian passport, and that he got into Nigeria without any of these passports. But he got into Nigeria. That's an offense. 2, that he came in here with a radio broadcast equipment, like a transmitter, into Nigeria. And these are some of the bases that the federal government, that the state, tried Nnamdi Kanu. Let's look at the laws. What does the law say about coming into a country without any form of documentation, one, and then bringing in a prohibited equipment? Because for you to do broadcast in Nigeria, you need to get a license from NBC for you to do that. So let's look at what the law says.
Okay, yeah. Well, when it comes to in respect of that, particularly coming into the country, we have strict immigration laws.
Yes.
If you come into a country without a passport, you need to actually enter into any country. You need to have a visa. Of course, as a Nigerian, you have the right to have dual citizenship. So that means that holding 2 different passports from different countries does not constitute an offense. as of today under our laws.
Yes. But the late former president said that. Where did he get that from? Because I've got a briefing from a legal practitioner that it was a crime for him to have come into the country without
coming into the country without the passport. Yeah. Without
but he's a Nigerian.
And of course, yes, like I said, and even ordinarily, there's what we call self-recognizance. At the point of arrival, they could have said, "Oh well, I'm displaying my passport in transit, and you should have arrived at the nearest police station or to the immigration officers who would give him a temporary pass or whatever, pending the time he's able to get his passport." So what they are saying is that I don't think that was what happened. What they are saying is that he snuck into the country, because that would be the charge. Coming into the country without a passport is not the offense, but it's about the intentions.
Yes.
And in law, there's what we call a mens rea. You need to have a mens rea. That's reasons for the action. That's what constitutes the crime, not just doing it. I can take this pillow to replace it back. And taking the pillow now and snaking it out is the crime, not taking the pillow. In the both instances, I've taken the pillow. One was not an intention of crime. The other one is intention of crime. So that's what probably that was what the president was talking about at that time.
Okay, so is extraordinary rendition from Kenya?
That's unlawful. And I always say that two wrongs don't make a right. When that happened, of course, even till date, Nnamdi Kanu has a right to sue the federal government and even the government of Kenya. And the appropriate place to take the action to is international courts, where there are treaties. If you say that you have a treaty with Kenya to repatriate people who have broken the law, there's a proper procedure to follow. You don't sneak people. Ordinarily, if you were in saner climes, like in the US or some other places, on the grounds of technicality, the trial would have, the defense would have gone for a mistrial because you brought the defendant or you brought the person before the courts improperly.
Condition that broke the law.
Yeah, exactly. Yeah. So, how can you...
it can be seen to be lawful whilst you break the law on the other hand.
Very well, So, but, in this instance, that didn't happen. But, of course, he still has the option of approaching the courts. And it should be compensated heavily for being treated that way.
So, if you hear Nnamdi Kanu speaks 10 times, 7 times you hear him say that it's a mistrial, that there is no case against him, that the state should provide the law upon which they are trying him, and that they should also put out the charges. He wants to see the charge sheet to get to know why he's being tried, because I think he's hinging that argument on the fact that he was tried, he had a case in the appeal courts, he appealed the case, and then he won. That under Nigerian law, no Nigerian law would have him tried for an offense that is not known or is blind to the Nigerian law. Help us make sense of the legal argument surrounding his claims.
Well, the charge that was filed against him in courts was it was brought pursuant to Section 1, Subsection 2 of the Terrorism Prevention Act of 2013 as amended. And now, what that particular section talks about is if anyone carries out an action, whether directly or indirectly, to suppress the government, to put pressure on the government, or to carry out a treasonable act. That's what that, I might not be quoting it verbatim, but that's the import of that particular section. And
in this court of public opinion, you can be excused, so you can go ahead.
Yes, so 7-count charge was brought pursuant to that law, to that act. Nnamdi Kanu is saying that they have not been able to pinpoint or establish that Nnamdi Kanu said that go against the government. I suppress. Do you understand?
Yes,
so that's his argument, that there was no. There's still ambiguity. They brought a widespread net, but without actually holding him down.
It was like a fishing game. It was like a fishing expedition where you go to test the waters and see whatsoever comes out. You use that.
So, that's his own argument. But
But does it stand? Does it stand? Does it hold waters in law?
He should have presented his defense in court, as opposed to saying that you won't defend the suit. You understand? This is a court of law. It's not a court of public opinion. If you are in court, somebody has laid some facts or allegations against you. The onus is on you to defend that suit. The court, no matter how pious, justiciable it wants to be, the courts cannot descend into the arena. The danger of that is that if the court descends into the arena to say, oh, I feel that Nnamdi Kanu has a case, or suo motu on its own, the prosecution would appeal to say that the court is descending into the arena and is biased. The same way Nnamdi Kanu can allege that the court is biased, the federal government can also say that the court is biased. So it is always proper and appropriate that the defendant presents his case. Why? Because cases that the law says that in criminal matters, the prosecution must prove beyond reasonable doubt.
So in this case, did they prove beyond reasonable doubt?
The onus was on Nnamdi Kanu
to debunk their proofs.
Exactly.
To debunk their alleged proofs.
Exactly.
So if there was anything
and cast a doubt.
Yeah.
Once you're able to cast a doubt to say, what do you mean? Have you been able to establish? I don't want to go into the substance of the case. So have you been able to establish that I was one on the radio? Can you say that, I said something 7 p.m. and it's happening simultaneously? There are ways that you could cast.
Where do you see this? Where do you see this appeal going? Where do you see it going?
Well, when you want to appeal, the law has, you have within 90 days you can bring an appeal, and when you bring an appeal, you can actually challenge the whole decision of the courts. You can challenge part of the decision of the courts. So I think that he will sit down with his legal team to explore and say, well, am I challenging the whole decision of the court, or I'm challenging some part of it? If you look at it, there are areas that you will say, oh, probably I feel that I was not well represented. I was not allowed to give my opinion. I was not allowed to raise my defense. I felt that the court shut me out. There are so many ways that he could, So the grounds of his appeal will now determine.
Where do you, let's look at his legal team. Let's look at them. And every lawyer goes into, just like a doctor goes into the theater room to come out, they shouldn't have stillbirth. Both mother and child should come out alive. And everybody should be happy at the end of the day. Lawyers also go to courts to make sure that they have happy clients. And that the more case you win, the more accolades that goes to your name and your person and your profile. How would you measure or rate his legal team?
Well, with all due respect, he had a senior advocate of Nigeria, who was a former Attorney General, Kanu
Agabi, yes.
That's a fine gentleman, the senior, who is the master of the law to a large extent. He had other members on his team. So I feel that he would have done a better job in defending this suit.
Okay. So would you recommend that he stays with them or try another set of lawyers to go on appeal?
Well,
it's an opportunity for you to sell yourself or sell your friends.
As it stands, we don't really know what transpired between he and his lawyers.
Yeah.
Because at the point they said that they were withdrawing from the matter because he was not listening to them.
Yes.
But what works best for him is to look at the best hands. We have so many constitutional lawyers that are very sound. To come and examine.
Are you a constitutional lawyer?
Yes, I am.
You are.
Yes, he can sit down with constitutional lawyers to look at the pros and cons.
Yeah.
They now determine, it's strategic. You now decide on the best step forward.
As we look to wind down and let's look at the political solution. There are this school of thoughts that people believe that legal solution wouldn't go down very well for this matter. Nnamdi Kanu versus the state. It won't go down well. That is should be more of a political solution. And this has been the far cry since the time of late General Muhammadu Buhari, that this case should be a political solution. And even we hear from certain quarters that Buhari had attempted to But the political players down the southeastern region of this country, they said it shouldn't be released because of elections that was coming up some years ago in those that part of the country. That if he comes out, he might, swing votes and all of that. So it's like Nigerians want him freed, but his people don't really want him free. What do you think?
Well, if you look at the gentleman in question,
yes,
his agitations is for his people to be free, to depart Nigeria and form Biafra. Now, if they are saying that they don't want him free, but nobody has come out openly to say that they don't want him free. And I believe that if people from his region mount pressure on the government to come and sit at the table, because of course there's always a need for political interventions, political solutions. The court has gone its way, but there are ways that in the event of resolving issues, parties can sit down and see how this can be resolved. But the major players, like you said, the stakeholders in the southeastern region, Nnamdi Kanu himself and the states can come together and map out a solution that would be beneficial to the people, which is the most important thing, that will not result into further loss of lives and upheavals in that region.
Before I let you go, let me put you on the spot, though not trying to bring any form of legal jeopardy, is to ask you, Nigerians, if you ask 10 Nigerians, if not 9, 8 of them will tell you that they've lost faith in the nation's judicial system. How can you guys redeem yourself? Is there anything you can do? Of recent, we had the judges' conference, and yes, that the gathering of judges. When I was growing up, when I was in school, we used to look for judges. I couldn't see a judge. I could see lawyers, but I couldn't see a judge. But these days, judges are everywhere, and at an event on your mandate we shall stand was played. Yes, one might say it was to herald the president, because that's what. But there are some, maybe they should play it in court. Anytime the president has a case, or maybe they should play it there. Is there redemption for this sector?
Yes, in respect of the judges' conference, the NJI has come out to openly condemn what transpired, and it was the president's band that played that song. Ordinarily, our professional
this president's band, they are paid for by taxpayers' money.
Yes, it was
They're
wrong.
not paid for the president's pocket.
Yes, it's inappropriate for them to have rendered that song. Ordinarily, in events like that, even in churches, you see people have to submit their praise worship list and all that for the songs to be played to whoever is supervising that event. And for that to come up was highly embarrassing. I agree with you. It's alarming, worrisome. Having said that, we don't throw away the baby with the bathwater. The judiciary is the last resort of the common man. We have 3 tiers of, we have 3 arms of government. The executive, the legislature, and the judiciary.
Yes.
They must stand apart because they are meant to be for checks and balances. And that means that the judiciary must be independent.
So if you were to rate them, what will it be? We don't have time. What will it be? 1 to 10, scale of 1 to 10.
I would say 5 over 10.
5 over 10. That's fair, but that shouldn't be. Nigerians would disagree with you.
We need 10 over 10. 5 over 10 is still we still have we still have a lot more to do.
Thank you so much for your time. Okay. Well, that's the size of our package today. It's been a wonderful time with a senior lawyer. His name is Oluwatodimu Ige. He's the man. He tried to crack his nut. He's a smart guy. I tell you, anytime, any day, follow him on socials and then keep it locked here. We'll be right back again, same time next week, God willing, and I remain Victor Ita. Keep it locked.